Good evening, everyone. On behalf of the Federalist Society Student Division and the University of Kentucky Federalist Society, welcome to tonight's Halloween edition of Feddie Night Frights between Professor Eric Segall and Professor Ilan Wurman. This is something of a rematch of an earlier debate between the same participants titled Originalism, Trick or Treat. My name is Samuel Weaver, and I'm the president of the Federalist Society chapter at the University of Kentucky's Rosenberg College of Law. I'm very privileged to introduce our distinguished fighters, as well as our honorable referee. First, our referee, Judge Lawrence VanDyke. Judge VanDyke is currently a judge on the U.S. Court of Appeals for the Ninth Circuit, having been appointed to that seat by President Trump in 2019. Prior to being appointed to the federal bench, Judge VanDyke served as the Solicitor General of both Nevada and Montana. He earned his law degree from Harvard Law School and clerked for Judge Janice Rogers Brown on the U.S. Court of Appeals for the D.C. Circuit. And now for our fighters, starting with Professor Eric Segall. Professor Segall graduated from Vanderbilt Law School, where he was the research editor for the Law Review and a member of the Order of the Coif. He clerked for Chief Judge Charles Moy Jr. for the Northern District of Georgia and Albert J. Henderson of the 11th Circuit Court of Appeals. After his clerkships, Segall worked for Gibson, Dunn and Crutcher and the U.S. Department of Justice before joining the Georgia State faculty in 1991. Professor Segall teaches federal courts and constitutional law. He's the author of the books Originalism as Faith and Supreme Myths, Why the Supreme Court is Not a Court and Its Justices Are Not Judges. His articles on constitutional law have appeared in, among others, the Harvard Law Review Forum, the Stanford Law Review Online, UCLA Law Review, the George Washington Law Review, and the Washington University Law Review, among many others. Professor Segall's op-eds and essays have appeared in the New York Times, the LA Times, the Atlantic, Slate, Vox, Salon, and the Daily Beast, among others. He has appeared on CNN, Fox News, MSNBC, and France 24, and all four of Atlanta's local television stations. He's also appeared on numerous local and national radio shows. Next, we have Professor Elon Wurman. Professor Worman is an associate professor at the Sandra Day O'Connor College of Law at Arizona State University, where he teaches administrative law and constitutional law. He writes on administrative law, separation of powers, and constitutionalism, and his academic writing has appeared in the Yale Law Journal, the Stanford Law Review, the University of Chicago Law Review, the University of Pennsylvania Law Review, the Duke Law Journal, and the Texas Law Review, among other journals. He is the author of A Debt Against the Living, an introduction to originalism, and The Second Founding, an introduction to the 14th Amendment. Little housekeeping notes here. At the end of this evening's debate, we'll open up the floor for questions from the audience. You must be logged in as a participant in the Zoom webinar in order to ask a question. Please use the raise hand function in Zoom to enter the queue. When we get to your question, Judge VanDyke will call on you by name, and the Zoom host will unmute your microphone so you can ask your question. If you're calling in from a phone, you can press *9 on your phone to raise your hand. And with that, I will hand it over to our distinguished referee, Judge Lawrence VanDyke.
Thank you, Samuel, for that generous introduction of all of us. Ladies and gentlemen, we have a treat for you tonight. See what I did there? We have a grudge match between Professors Worman and Segall, as mentioned. And I think this may be the first grudge match in Feddie Fight Night's history. Last time our professors talked about originalism. This time we're going to have another originalism discussion, a little originalism redux, plus maybe some departmentalism, a little 14th Amendment thrown in there, and whatever else we can find that we can get our professors to disagree about. Last year, about this time, these very same professors squared off in what many called the fight of the century. They both left bloodied and bruised, staggering from the ring, but nobody was able to say that either of them landed a clear knockout blow. And the rumor in faculty lounges across the nation has been that both our professors have been talking smack about each other ever since. So we brought them back for an epic rematch. They've been training all year for their second chance at vindication, doing pretty much nothing else is what I've heard. In fact, I'd be surprised if either man leaves the ring standing tonight. A little additional fun fact about Professor Wurman. He confided in me that in the last match, he felt like Eric was just being a little too physically aggressive in the last match. So Elon has since joined CrossFit, and he's confident that that's going to give him the edge against Eric this time around. He also says that his favorite Halloween candy is dark chocolate, which matches the color of his soul. And if that doesn't strike fear in Eric, I don't know what will. Speaking of Professor Segall, a little fun fact about Eric. He says he's a Reese's Cups guy, which I think is a strong choice in my book, but it's a little ambiguous on what it says about his soul. But he also said he's so old that he remembers when the Portland Trailblazers chose Sam Bowie from Kentucky over Michael Jordan in the NBA draft. And by that, I interpret Eric to be saying he's not intimidated at all by Ilan's new CrossFit dalliance. Old age and treachery will beat youth and fitness every time. And I agree with Segall on that. And with that, I don't think there's anything left to say. This is going to be an ugly fight, but an enjoyable one. Gentlemen, please take your corners. Here's the rules of the match. Ilan, you're going to start, followed by Eric, and then there's going to be rebuttal from Ilan, and then we're going to follow with Eric's rebuttal. And assuming these guys have any gas left in the tank after this brutal back and forth, then we'll do some Q&A. I'll probably start out the Q&A, but then we'll, audience, please feel free to use the raise your hand function in Zoom to queue up your questions. If you don't know how to use that function, then I don't know where you've been for the last 2 years. All righty then, gentlemen, it's time to ring the bell. Ilan, take us away.
Great. Well, it's a pleasure to be back with you all. There are at least 2 occasions for this quasi-rematch. The first is the topic of court reform. The second, if I can talk about myself for a second, is the publication of my new book, The Second Founding, An Introduction to the 14th Amendment. I don't know if you can see it in the background, but amazing cover. The 2 topics, I promise you, are related. So the question before us is whether the Constitution needs to be saved from the Supreme Court, which I think is just another way of asking whether we need to reform the Supreme Court. My answer is a resounding, qualified no. My claim that the Supreme Court is not in need of reform because a properly originalist Supreme Court is not a court that needs to be feared. It is not a court that needs to be reformed. In fact, I think the court should be more originalist. And if it were so, we'd have even less reason to fear it and even less reason to save the Constitution from it. So originalism is the idea that we should interpret the Constitution with its original meaning. An originalist court need not be feared, I submit, for at least 3 reasons. First, the correct originalist answer to many constitutional questions do not lead to predictably conservative outcomes. Right? The answer to at least some questions, maybe even a lot, can be the preferred progressive result. Second, in many cases, I think the correct originalist answer has no particular political valence. And third, and related, I think, to the second point, in many controversial cases, the Constitution leaves the answer to the democratic process, where the libertarian or the progressives or the conservatives might win the day. Now, I'd like to make this case by briefly describing the argument for the originalist 14th Amendment, and particularly the original meaning of the Privileges or Immunities Clause, the clause that provides no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. If we were to recover the original meaning of this clause, I think we'd have even less reason to fear an originalist Supreme Court. So here goes. Many originalists believe that this clause incorporates the Bill of Rights against the states. Others believe the clause not only incorporates the Bill of Rights, but also guarantees a fundamental minimum of other unenumerated, unwritten rights, such as property and contract rights. Well, in my new book, I show, or at least I argue, that the best original meaning of the Privileges or Immunities Clause is that it is likely not a fundamental rights provision at all. It is instead an anti-discrimination provision with respect to civil rights under state law. If I'm right about this, then I think that means that California can ban handguns. What California can't do is say only white people can have guns. So why am I right about this? Well, because it is beyond question that the key objective of the 14th Amendment was to constitutionalize the Civil Rights Act of 1866. That act sought to invalidate the notorious Black codes that had arisen in the South after abolition, by which the Southern governments systematically denied basic civil rights to the newly freed population. For example, prohibiting them from owning firearms or from owning real property. Hence, the Civil Rights Act of 1866 declared, all persons born in the United States are citizens of the United States And such citizens of the United States and such citizens of every race and color shall have the same right in every state and territory to make and enforce contracts, to sue, be parties, and give evidence, to inherit, purchase, lease, sell, hold, and convey real and personal property as is enjoyed by white citizens. The Act, notice, does not guarantee any civil rights at all. The states can continue to define and regulate the content of their contract and property rights, for example. But if a state provides some right to its white citizens, it must also provide that right to Black citizens and other citizens, free of arbitrary discrimination. But where did Congress get the power to enact the Civil Rights Act and interfere with the civil rights legislation of the states? It did not have such a power, which is why we needed the 14th Amendment, at a minimum to give Congress a constitutional grant of power. But more than that, it was necessary to embed the requirements of equality of the Civil Rights Act in the fundamental law itself, lest future Democratic majorities repeal the Reconstruction legislation of the Republican-led Congress. It was necessary, in the words of future President James Garfield, to enshrine the civil rights law in the eternal firmament of the Constitution. The question is, which clause of the 14th Amendment does the job? I submit the Privileges or Immunities Clause. Note the parallel to the Civil Rights Act. That act begins with a declaration of United States citizenship and then provides that such citizens of the United States are entitled to equality in civil rights under state law. The 14th Amendment also begins with a declaration of United States and state citizenship, and then provides that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. The language also does the trick and the treat. See what I did there, Judge? Okay. The word abridge often denoted the giving of lesser scope of rights to one class of citizens than another. The biggest hiccup is usually the term privileges and immunities of citizens of the United States. Doesn't this refer to the Bill of Rights? That's certainly plausible, but that reasoning collapses upon a moment's reflection, because United States citizens have privileges and immunities from multiple sources of law. We have privileges and immunities from the Constitution, to be sure, but also from federal statute law. And what would it mean to incorporate those? And we have privileges and immunities under state law, our state constitutions, state statutes, and state common law. It just doesn't make sense to limit the phrase to the federal constitutional rights. It's just as plausible, if not more plausible, to think the phrase refers to those privileges and immunities of US citizens that it is within the power of the states to abridge in the first place. Look, if you're still not convinced, 17 members of the Reconstruction Congress specifically connected the Privileges or Immunities Clause with the Civil Rights Act, compared to 2 who said anything coming even close to something kind of like incorporation of the Bill of Rights. Okay, now to be sure, maybe my reading is redundant if what we all think about the Equal Protection Clause is true, but it's not. The protection of the laws did not require equal rights. The protection of the laws was a legal concept whereby the government had to protect its citizens from interference in their enjoyment and exercise of rights from other private citizens. Mob violence, private violence, was the quintessential failure to provide protection of the laws. Okay, well, why do I rehearse all of this tonight in this debate? Because in my view, if the Supreme Court were more originalist, then we would not need to save the Constitution or the court. Because consider the implications of a properly originalist 14th Amendment. First, under the originalist 14th Amendment, Brown v. Board of Education is an easy case. Is public education a civil right under state law? Of course it is. Whether it was in 1868 or not, in 1954, if the states offered it, it's a civil right under state law. The question then becomes whether separate schools abridge the rights of Blacks by discriminating against them. And forgive me for thinking that that's actually a pretty easy question. This reading that, by the way, I think makes a plausible case for Obergefell v. Hodges. Not foolproof, but plausible at least. And if I am right about the protection of the laws being an affirmative duty to protect against private violence, then that means state inaction can violate the Constitution. And Congress can enforce the amendment by supplying the protection of the laws. Thus, cases like DeShaney, I think, are likely wrongly decided, and perhaps U.S. v. Morrison, invalidating the Violence Against Women Act. Since I'm on the enforcement power, let me give another example. The conservative majority in Shelby County v. Holder was wrong to invalidate the formula of the Voting Rights Act. There is no equal sovereignty principle in the Reconstruction Amendments. Congress could, if it wanted, enact the Mississippi Enforcement Act, leaving the problems of Georgia or California for another day. Conservatives may not like the result, but nothing in the Constitution prevents Congress from enforcing the Reconstruction Amendments selectively. What about incorporation? Well, under the best originalist reading, the one I've advanced today, there'd be no incorporation of the Bill of Rights. This might sound crazy, but it's not. It might even be awesome. All the states, after all, had equivalents of these rights in their own constitutions and still do to this day. The 14th Amendment thus guarantees that any such rights in the state constitution must be given equally. But the states are still free to experiment with rights. Thus, California can experiment with prohibiting corporate speech or guns. And Texas can experiment with abolishing Miranda warnings or the exclusionary rule. God forbid that we'd have some diversity among the states. Finally, on many controversial rights, the best originalist answer will likely leave the question to the democratic process. For example, even if the standard originalist view of Roe v. Wade is correct, then abortion isn't prohibited everywhere. The question is merely left to the states where we, the people, can decide. So do we need to save the Constitution from the court? Well, not if the court doubles down on originalism. Originalism generally, and the Originalist 14th Amendment in particular, often leads to results that progressives want. Oftentimes, it has no political valence at all, as I suspect is the case with my argument as to incorporation. And still other times, it will leave important questions to the democratic process, probably where they belong. Okay, now let's assume that I haven't convinced anyone that an originalist court is not one in need of reform. Well, the second overarching point I want to make tonight, and with this I'll conclude, is that there is a mechanism within our existing constitutional framework to diminish the power of even an originalist Supreme Court over controversial social and political issues. This mechanism is what some scholars call departmentalism. It is the idea that the Supreme Court's decisions need not necessarily be followed as a political rule, although of course its judgments are binding in particular cases. Departmentalism does not challenge the validity of Marbury v. Madison in judicial review. Chief Justice Marshall held simply that when judges engage in their judicial duty to decide particular cases, that's in his language, they have no choice but to interpret the applicable laws and decide which law applies in the event of a conflict. That does not mean, however, that the Supreme Court's interpretation in that decided case must ever and always be followed by the political branches. The point is obvious when the Supreme Court upholds the constitutionality of a law, in which case nothing prevents Congress from repealing that law or the president from pardoning individuals for offending against that law when they nevertheless believe the law to be unconstitutional. Even when the Supreme Court, here's the tricky part, even when the Supreme Court holds that a congressional law or governmental act is unconstitutional, that still does not necessarily mean that the political branches must immediately follow the reasoning of the court as a political rule. When the Supreme Court, in its willful, racist, and thoroughly non-originalist opinion in Dred Scott v. Sanford, I'm just trying to trigger Eric as much as possible here. So in its I'll repeat, thoroughly non-originalist opinion in Dred Scott v. Sanford, when it invalidated the Missouri Compromise and held that no Black Americans could be citizens of the United States, it was Stephen Douglas who argued that the Supreme Court is the final arbiter of the Constitution's meaning, and that its decision in Dred Scott should be treated as resolving the controversial questions of congressional power and Black citizenship that were then threatening to rip the country asunder. Abraham Lincoln disagreed. The judgment in that case was certainly binding on the parties, but Lincoln argued Congress need not follow the reasoning of the court as a political rule. Nothing should prevent Congress from continuing or attempting to continue to enforce the Missouri Compromise. And maybe a more obvious example, nothing prevented Lincoln's administration from issuing passports and coasting licenses to Black individuals, even though the laws at the time required that such persons had to be citizens of the United States. Lincoln argued that only when a matter has been decided consistently over a course of years, in accordance with or at least with the acquiescence of the political departments and the people, only then would it be revolutionary to ignore the court's precedents. On this view, judicial decisions are just one input into a greater constitutional conversation. So in conclusion, an originalist court, in my view, is not one in need of reform. And an even more originalist court would be even better. But we should nevertheless reinvigorate the concept of departmentalism in our constitutional and political culture to diminish the power of the court to shape and resolve modern controversial social issues. That's all I've got. Thank you.
Well, thank you, Ilan. There's said a few controversial things here, so we'll see if we can get Eric to bite on any of those.
Well, thanks everybody for having me again for the second year in a row. I really appreciate being invited back. I always enjoy discussing issues with Elon, and I appreciate the Federalist Society inviting me. So I don't have time to respond to everything Elon said because he said a mouthful. Let me begin with this. I am not going to get into an historical debate with Elon, but it may be not for the reasons you think. So as part of my work on originalism, in my book, Originalism is Faith, and other places, I have agreed with many other critics that the worst kind of history is law office history. Now, I want to be clear about something. I think Elon is a brilliant, I'm going to call him young because he is, a brilliant young scholar who has written a tremendous amount of interesting, provocative, noteworthy, important work in a dozen or so articles and 2 books. So I want this to come out the right way. Elon is taking on people like Kurt Lash, who has been doing this for 30 years or 25 years or something, other famous constitutional law professors who have written books and treatises on this subject. He disagrees with them on a lot of points. In Elon's book, and by the way, thank you, Elon, for citing me in the introduction. I always appreciate that. That was kind and classy of you. Elon's book talks about history from the Magna Carta in 1215 to the Petition of Right in 1628 to Blackstone to 1868. And I'm very bad at math. I think we're all bad at math, but that's about 550 years, which is twice as long as America has been around. And he does all of that. Well, his entire book is 140 pages. The entire book is 140 pages. So I think Elon's history here has to be looked at as the quintessential attempt by a lawyer to engage in a practice that maybe lawyers should be very careful about engaging in, especially someone like Elon, who I've described Elon as brilliant before, and I believe that when it comes to constitutional law, doctrine, arguments, etc. One cannot go from the Magna Carta in 1215 to the Petition of Right in 1628 to Blackstone to the Civil War in about 30 or 40 pages or whatever it is. It can't be done, and we shouldn't try. And what I mean by that is when he says he wants a more originalist Supreme Court, I would take Elon's history over Justice Roberts' history or Justice Kagan's history any day of the week. I think Elon has better historical skills than both of those people. But what I do not want is law professors of any, Ilan does not have a history degree. In fact, I believe his majors in college were physics and government of some kind. So when people like, when real historians debate these issues in treatises over centuries, and a law professor steps in, I am not going to debate him on his historical evidence. I am not qualified to do so. So that's the first point I want to make. And I have to say, I hope Ilan's future work centers more on doctrine and law than history. I hope he's not offended by that, because I want to hear what he says about those other things. I am not interested in Ilan's perspective on 1215 and 1628. I'm just not. I'll go to the history books for that. So that's the first point I want to make. As to his actual proposals about the privileges or immunities clause in the 14th Amendment and the Equal Protection Clause, the name of this discussion or debate or fight, I believe, was does the Constitution need to be saved from the courts? A topic I've been writing about for 30 years. I think I now feel like we need to save the Constitution from Professor Wurman, because he is really trying to sell you a bill of goods here. So let me back that up in a couple of ways. My study of the Supreme Court of the United States from 1803 until today is that pre-existing theoretical commitments do not work. They don't work on the left, they don't work on the right, and they certainly don't work on the center, right? People like Blackmun and Souter and White, O'Connor, Kennedy, they didn't even have any pre-existing theoretical commitments, but they don't work, they never have. And if Judge VanDyke, who I respect very much, was on the Supreme Court, or if Elon was on the Supreme Court, or if I was on the Supreme Court with life tenure and unreviewable power other than the possibility of constitutional amendment, pre-existing theoretical commitments would not bind us either in cases we care deeply about. I find it fascinating that Elon wants to have what he says a more originalist Supreme Court. My book, Originalist Faith, shows we've never had an originalist justice, never. Not Thomas, not Scalia, not Gorsuch yet, not Kavanaugh yet, not John Marshall, not anybody in between. We have never, ever had an originalist justice who was willing to, and certainly Justice Barrett's not going to be this. We know that from her work in the Seventh Circuit. We've never had a justice who, on issues they feel deeply about, were willing to say, yeah, I feel really deeply about this, but I found some document in 1790, or I found some set of historical materials, so I'm going to vote the other way. It does not work that way. It never has. It never will. Now, if we take away life tenure and we have fixed terms and we take them off their marble palace on a hill and we put them on TV and we do all kinds of other things, we can have that conversation. But as the Supreme Court currently is constituted, there's never been an originalist justice. Scalia and Thomas, in their affirmative action decisions, in their anti-commandeering decisions, if we can just start and stop right here. The First Amendment was about prior restraints. Judd Campbell has shown in a brilliant Yale Law Review article that an originalist Law Review article, that the founding fathers did not equate natural rights with judicially enforceable rights. They just didn't. And when they thought about the First Amendment, they thought about prior restraints. Our entire First Amendment jurisprudence, whether we're applying it to the states or to Congress, is an invention of the Supreme Court. Now, we may like that invention. I think some of us probably do to some degree. It is as anti-originalist as anything can be. And that's really my point. Justice Scalia in Texas versus Johnson wrote an incredibly unoriginalist, anti-originalist decision. Same thing in Prince, same thing in all his affirmative action cases and so on. So when Ilan says he wants a more originalist Supreme Court, the more correct phrasing of that wish is, I would like to find one originalist justice ever, because he can't point to one. And no one in the crowd will be able to too. Some people point to Justice Black, not true, not how he decided cases. So that's what I want to say about that. On departmentalism, which brings us a little bit closer, which I'll explain in a minute, I'm interested in this because I want to weaken the court as much as any legal scholar in America. But the way Ilan would do it is absolute chaos. So the Supreme Court decides that affirmative action is unconstitutional. because it violates the non-textual, anti-originalist, colorblind principle concocted by Scalia and Thomas in their dreams. And then Georgia says, my law school, public law school in downtown Atlanta, part of the state of Georgia, says, you know what, we don't care. You said an Oklahoma school can't use affirmative action, but we're different and we can, and we're going to, and try to stop us. And I don't understand how that's going to work. And I did ask Elon this in a pre-call, what would happen when, the states or Congress just say to the Supreme Court, we're not going to follow your decisions. And he said candidly, and he's very honest, I love this about him, I haven't really worked all that out yet. Well, that's the thing. Now, the irony to me is that his reading of the Privileges or Immunities Clause and the Equal Protection Clause gives both the Supreme Court and the Congress more power than any Federalist Society person I have ever heard in my 30 years of teaching. It would make Ed Meese turn over, well, he's alive, I guess, but if Ed Meese heard this, he would go, what are you talking about? If Congress can prohibit inaction on the states, which by the way, I'm okay with that. But if Congress can do that, there's almost nothing Congress can't do. And what is arbitrary discrimination? Ilan has no answer to that. So for example, just the other day, students at my children's private school, not public, private school, wanted to have urged the school to put women's products in the boys' bathrooms because there are 8th and 9th grade girls in that school who identify as non-binary, and they want to not use the women's bathroom, girls' bathrooms. And when Elon talks about how the arbitrary discriminations by private people can possibly violate these constitutional provisions or allow Congress, God forbid, to legislate on that subject, because what is an arbitrary discrimination is in the eye of the beholder. And that's the problem. It doesn't matter whether it's the Equal Protection Clause or the Privileges or Immunity Clause. If the question is this an arbitrary discrimination, we can recast almost any constitutional law case involving speech, guns, same-sex marriage, transgender rights, anything in an equality context. So I have a better idea. Let me save the Constitution from the courts. And this is how I would do it. And I'm going to be 10 times more originalist than Elon when I say this, which the irony of that should be frightening to everybody. And by the way, Dred Scott is an unconscionably originalist opinion. Tani has like 6 paragraphs on how we're not at liberty to change what they thought in 17. He even says, even if like modern political, he didn't say correctness, but he used that kind of word, even if it's changed, we're not at liberty to change what they decided in 1787. So that's a ridiculous thing. But here's my answer. I'm going to read you the words of a guy named Brutus, wasn't his real name, from 1787, who anticipated all of this and who was right and who we should listen to today. And this is what Brutus said, says the progressive non-originalist. This is what Brutus said in 1787, quote, I question whether the world ever saw a court of justice invested with such immense powers and yet placed in a situation so little responsible. There is no power above them to control any of their decisions. There is no authority that can remove them. They are independent of the people, of the legislature, and of every power under heaven. Men placed in this situation will generally soon feel themselves independent of heaven itself. That has come to be true. That's not arguable. When Justice Thomas votes to strike down every affirmative action law he's ever seen based on a non-textual, anti-originalist, colorblind principle in a country that had racial discrimination from 1787 to today, we are looking at a man who feels he is not bound by heaven itself. So here's a better answer. And again, I'm going to be originalist. Thank you. I go with Alexander Hamilton. I've always gone with Alexander Hamilton, not the actor, but the real guy. And what he said made sense then, and it makes sense today. In response to Brutus, he said, relax. This is Federalist number 78. Relax, calm down. They don't have the purse or the sword. I think Elon's going to agree with that part of this. But then he also said, judges will not strike down laws and should not strike down laws unless they are at an irreconcilable variance with the Constitution or against the manifest tenor of the Constitution, which meant the same thing. And I have done the research. My book has historical sources all over the place, that the people who thought about judicial review for the first time in the late 18th century, first time ever in the universe, or at least on Earth, what they said was, this is an immense power, and we have to do it with humility, with modesty, and only as a last resort. And another way of putting it is only when the error is clear, which is exactly what Marshall said in Marbury versus Banks. He made up a law that didn't exist, so nobody cared that he struck it down, but he quoted pretty much, paraphrased Hamilton. We're only going to do this when the constitutional error is clear. Now, my last thing I'm going to say is, when the standard is arbitrary discrimination, I mean, that's so loosey-goosey. I mean, that's all in the eye of the beholder. So my idea here is to bring the court back to the Constitution, back to Brutus, back to Alexander Hamilton, back to the people who first thought about judicial review, under the veil of ignorance, not knowing whose government would control. And what they said is judges should almost never do this. They should do this only if the error is crystal clear. Here's what judges understand. They understand burdens of proof, and they understand presumptions. They don't understand history unless they studied it. They don't understand arbitrary discrimination any better than, here I am citing Scalia, 9 people picked at random out of the Kansas City phone book. What they do understand is presumptions and burden of proof. So for instance, Judge VanDyke, I am sure, takes his obligation very seriously not to reverse lower courts on factual findings unless they're clearly erroneous. It would be against his job and maybe even against his oath to do that. And I'm sure he doesn't. I know a lot of Court of Appeals judges in good faith. They do not reverse district court judges very often on factual findings. There are renegades, of course. There are hard cases. But 95% of the cases Judge VanDyke decides, he does not reverse district courts on factual findings. That's the kind of standard we need. That's the kind of burden judges, lawyers understand. And that is the only way we will ever save the United States Constitution from the Supreme Court of the United States. Thank you very much.
Well, thank you, Eric. Great comments by both of you, but I'm just disappointed because I don't feel like there's any disagreement at all. Could you guys please bring it up like a little bit of a level here? We're going to give it back to Ilan for some rebuttal. And can you find something to disagree with, Ilan, with what Eric said?
So Eric, what does Judd Campbell say about fighting words? Because that's how I'm feeling right now. So there was a lot said there, and I feel like I have to defend myself. So first of all, of course, my book is called The Second Founding, an introduction to originalism. It doesn't purport to be a comprehensive account.
14th Amendment.
An introduction to the 14th Amendment. Yeah, sorry. And because it's only 144 pages, people actually read it. And maybe that's what upsets all those other scholars with whom I disagree. But in any event, it does have 40 pages of endnotes that were omitted out of the 144. But okay, let's talk about the absence of a history degree. By the way, yes, it's true. I majored in physics. Full disclosure, if I were any good at physics, I probably would be here today. So law school is always the last refuge of people who failed at everything else. Anyway, this question, okay, of whether you need a history degree to do history really gets my goat, okay? Because you know why? For a number of reasons. First of all, lawyers aren't, most of them, judges, practicing lawyers, certainly most judges, they aren't economists either. They aren't sociologists. They aren't even linguists. They don't even have PhDs in moral theory. And yet sometimes law requires them to interpret language. Sometimes it requires them to analyze economics and contract or tort suits. The extent to which any of these fields, including history, is relevant for law is only a question that law can answer, that law itself can answer. And if law requires some amount of economic knowledge or linguistic knowledge or historical knowledge, then we have to engage with it as best we can, including by relying on historians and historical work. But also this thought that historians, to do good history, must have a PhD from Northwestern University History Department is just really crazy to me. I mean, some of the best historians, didn't have a PhD. Thucydides didn't. Herodotus didn't. Okay, yeah, there are problems with their history. There are problems with the historical work of many modern historians too, even those with the PhDs. The point is, this idea that you always be wary of people who claim that somehow they are privy to exclusive knowledge because of their credentials or background, okay? People can be really good at things without having gone to the fancy school and gotten the PhD. And just be very, very cautious, okay? When anyone says that they are uniquely, the exclusive knowledge is sort of uniquely within their purview. So I think that should just be rejected. But okay, fine. So much. Let's talk about Dred Scott. Okay, since I disagree. Yes, it's true that Chief Justice Taney purported to apply an original intent sort of approach. There's no question about it. But what's also very clear is that Chief Justice Taney was ascribing to the founders the intellectual and cultural prejudices of his own time. Now, look, okay, maybe Professor Segall will say, well, but that's the problem with originalism, because you're always going to ascribe modern day culture and understandings. Fair, but make no mistake about it. That was not an accurate portrayal of the founders' view. In Chief Justice Taney's era, in the 1850s in the South, they had developed what's called the positive good theory of slavery. Okay, this was not developed until the 1820s and 1830s by Calhoun, Fitzhugh, and others. Okay, don't take my word for it. Okay, right? So Chief Justice Taney said, how could the founders possibly have believed that people of African descent were citizens when they were forever held and understood to be a degraded and inferior race? They would have been gross hypocrites if the founders intended to include them. Well, here's what Senator Robert Hunter, this is actually not Hunter himself, this is someone relaying what he had said, and it was then affirmed by Hunter's colleague. Okay, but here's what Senator Robert Hunter said on the floor of the United States Senate in 1860. Senator Robert Hunter, by the way, Virginia. He said the following: we in Virginia have changed our ground. We no longer believe what James Madison believed, Monroe believed, Thomas Jefferson believed, George Washington believed, and all the leading men of Virginia for the first 50 years of our existence under the Constitution believed. We have shifted our ground. We no longer believe that slavery is an evil to be restricted and discouraged and eliminated as soon as possible. We now believe slavery to be a positive good, a good for the enslaved person and for the black man and the white man, he said. Okay, take it from the Southerners themselves. They had shifted their ground. So certainly Taney was purporting to apply originalism, but make no mistake that he was ascribing to the founders his own intellectual and cultural prejudices, those of his own time, not the founders' time. Okay. How much time do I have?
Can I respond to those points? And then
sure. And the only other things I want to say is departmentalism and arbitrary discrimination. But why don't we split it up?
Yeah. So first of all, it is the height of irony that you are ascribing to Justice Taney bad originalism in response to my presentation that all we've ever had on the Supreme Court for all of history is either no originalism or bad originalism. So, all right, fine. Taney thought he was doing originalism, but you say he does not, he did not. Well, that's Justice Thomas. That's just Taney to Thomas right there. It's a direct, I'm not saying Thomas is as bad as Taney, but I am saying that his view of affirmative action is as absurdly wrong as Taney's view was about that. And we can talk about all the cases in between. Second, we must, the Federalist Society must, everybody listening to this has no choice but to stop talking about originalism in the singular. That is demonstrably false. Originalism is a they, it is not an it. Professor Ilan and Steve Calabresi, the co-founder of the Federalist Society, now believe that, Calabresi has said this and you've suggested it, that same-sex marriage bans can be overturned by judges on an originalist basis. We're done. We're done because the original public meaning of the 14th Amendment in no possible way in no possible way can say same-sex marriage bans are unconstitutional. Randy Barnett would have an entire libertarian, structure of government based on his view of the originalism of 1791 and 1868, even though he has never responded a syllable to my argument that judicial deference was the original way of thinking about the Constitution. We have originalists who are incredibly strong judicial activists. We have originalists who are incredibly strong deferentialists like me, like Steve Smith at San Diego, and we have everything in between. So every time I speak now to the Federalist Society, I'm going to make this point. It is a family of very different theories. And the normal response by Ilan and Calabresi and Larry Solomon is, but we all agree on one thing, the original meaning was fixed. No, it wasn't. You don't agree with that because you think women have equal rights today, and that means the original meaning has changed, or the application of the original meaning has changed. Fine. The application of the original meaning has changed. You, in fact, have said in your first book, in law review articles to me, privately and publicly, that when values, facts, and circumstances change, applications can change. Welcome to the world of living constitutionalism. Now, why did you make that change? In fact, why are you, I'm just going to sound incredibly pompous and arrogant. I have been studying this for 30 years, and unlike you, when I started in 1991, originalism was all about deference. Originalism was all about, unless the plaintiff comes into the court with absolutely clear evidence that this statute violated the specific original meaning or intent of the Constitution, judges should stay away. That was the originalist trope in 1991. That's what Ed Meese said. That's what Ronald Berger said. That's what Robert Bork said. They all said it. You know what happened? We didn't find new originalist materials. We didn't find somebody responding to Brutus in some other way than Hamilton did, which was deference. You know what happened? Reagan and Bush had 12 years of judges. So now, as Keith Whittington, an originalist at Princeton, says, people in power needed a theory to justify strong judicial review because they own the courts. And that's what got us Heller right there. So the notion that originalism is going to bring the court closer to the Constitution is as utopian as any view I've ever heard. And your statements about Tani, I think, absolutely support that. Finally, and then you can respond. This whole thing about history, I don't understand what you're saying. First of all, when we talk about fancy schools, I'll put up Emory and Vanderbilt as not fancy against the schools you went to. So we'll start there. So don't accuse me of anything having to do with that kind of trope, because I'm the last, I'm probably I don't get hired today. I do not get hired. No law school hires me today. Not from Emory and Vanderbilt. Not a chance, no way, no how. So don't throw the word fancy at me. Second of all, you use the word exclusive. I understand that there are times when judges have to go back and try to figure out the context of a statute or a constitutional provision the way it was, meant at the time. I get that. They should do that with unbelievable humility. Now, in statutory interpretation cases, it's complicated. We're not here to talk about that tonight. I'm debating Chief Justice Namias of the Supreme Court of Georgia, a former Scalia clerk, on Friday on that issue. I'll try not to get confused. But in constitutional law, the answer is where history is contested, which is every case, where history is contested and text is ambiguous, which is every litigated case almost, except for ironically the 11th Amendment, where of course they went the other way of the unambiguous text. When history is contested and text is ambiguous, judges stand down. And that is the only way to get judges to stand down. That's Alexander Hamilton thinking about this without knowing who's going to be in power, without knowing if his side was going to win or lose. And if you get more complicated than that, then the court will not stand down. So what I think would be an interesting thought experiment would be if Congress were to pass a law tomorrow saying from here on in, the Supreme Court's jurisdiction, appellate jurisdiction, only extends to those laws that are at an irreconcilable variance with the United States Constitution. Now, you and I both know what the Supreme Court would do with that. And you know what? It would be an anti-originalist decision if they were to strike that law down. I think we need to figure out other ways to save the Constitution from the courts other than original. Except Robert Bork's version and my version, which actually would work.
Well, okay. So I think in response, I do want to say something. What's this?
You are.
Okay, I'm just spotlighted. There we go. I think I do want to say something about departmentalism, and then also this arbitrary discrimination point. So yes, it's true that history can be contested. Linguistic meaning can be contested. Lots of things can be contested. That doesn't mean there isn't a right answer, right? I mean, a diversity of an opinion.
I apologize, my last interruption. I just want to say that this is the answer I get from Federalist Society people in 2012 to today. It's the Ronald Dworkin answer. The Federalist Society has adopted Ronald Dworkin. Good night. All right, I'm done.
He wasn't wrong about everything. Okay, you should probably turn your camera back on.
All right.
Okay, there. So I will say again, just this trope about originalism. Oh, well, they disagree among themselves, so it can't be right. Well, hold on, right? I think more often than not, right, the best originalist interpretation will lead to a range of plausible answers to many constitutional questions, but a range is still a range. A range still has endpoints, right? And so, maybe Congress has discretion to confer the removal power on the president. Maybe the president is invested with the removal power by Article 2. But what we know pretty much for sure that everyone thought was wrong was that the Senate had a say in it, right? At least at the beginning, right? A range is still a range. Just because there's contestation doesn't mean there aren't better and worse answers. But look, within the range of plausible contestation, this is where departmentalism would come in, right? So let me elaborate more about this, right? Because in a realm of contestation, an ambiguous constitutional meaning, why would we say, oh, well, the Supreme Court says X, right? But Y is plausible and Z is possible, right? Why would we just go with what the Supreme Court says? In one particular case, you want an ongoing conversation, what Madison described as liquidation, right? He described it as a series of discussions and adjudications would liquidate, would ascertain, would determine the constitutional answer. It doesn't mean that it's the best answer. It doesn't mean it's the answer that you might have come up with if you were deciding the question de novo for yourself without any previous discussions and adjudications. But the point is, it's within the range of meanings. And that at least does some work. So for example, James Madison, excuse me, this is the CrossFit I did earlier today in preparation for today. So it caught my throat a little bit. Sorry. So James Madison.
You've got him on the ropes, Eric. You've got him on the ropes.
That's right. I see. I'm tired. Okay. So James Madison thought that the Bank of the United States was not constitutional, that the Congress did not have the power to incorporate a bank through the necessary and proper clause. There were plausible arguments on both sides, though even then, by the way, everyone actually agreed with the core meaning of the necessary and proper clause. Everyone in the debate agreed that the clause was a grant of implied powers only, not great and substantive power, right? So what does this mean? If Congress didn't have the power to tax, specifically enumerated in Article 1, Section 8, could you imply through the necessary and proper clause a power to tax? Everyone said no, because that's a great substantive and independent prerogative, right? Which is also the argument, by the way, why Congress may not have the power to abrogate sovereign immunity. Now I'm really triggering Eric, but you're going to have to wait. I said it because I knew it would trigger you, right? All agreed on that. They sort of disagreed on the lower order question of whether incorporating a corporation, right, like a bank, is in fact a great substantive prerogative or not. And then they debated on whether necessary had to be absolutely necessary. Okay. Now, when Madison became president, he was presented with the opportunity to veto the rechartering of the bank, and he refused. He said, I had constitutional scruples about this before. I still think, I'm paraphrasing, right, and reading a bit into his thoughts here, right? The best constitutional answer is probably still that this was not, Congress didn't have this power, but there are plausible arguments on both ways, and the question has been settled for 25 years. I'm not going to veto it because I think the best constitutional answer, right, is that the Congress doesn't have the power. In other words, at some point, this goes to Eric's earlier assertion that I don't quite have it all worked out, which is true. I don't have many things worked out. And God forbid, I'm a lot younger than you, Eric. I don't want to be fixed in my views.
Unfair, not fair.
All right. So the point is, right, at some point, as even Lincoln said, good faith requires that you treat a constitutional question as settled. But RFRA, or I should say the Employment Division v. Smith test for free exercise, that was not settled, right? When you have 4 justices who vigorously disagree, basically a unanimous House and Senate, a president of a different party, right? It's like at some point the court should maybe reconsider and think, look, this one decision that we made doesn't establish this as law. So that's that point. Okay.
I'd like to make 2 points in response.
Yeah, go for it. And then with the judge's indulgence, I will say something about arbitrary discrimination.
All right, two points. First of all, you have this habit of taking easy cases and suggesting we can generalize from them. First of all, James Madison could have vetoed the bank on policy grounds. He didn't have to. I mean, there's a lot of politicking going on there, and you know that. I mean, there's a lot of politicking going on. But what I really want to say, though, on this departmentalism issue is we could probably work hard to find common ground here. That wasn't the rules of the fight, so I'm not going to do. I mean, I like finding common ground, especially with people, But I do want to say that it is, as someone who's been doing this for 30 years and is much older than you, sadly, and doesn't do CrossFit, though I should. It is. When one begins one's career as a lawyer for the Bush Department of Justice in 1986 and works, 88, and works for Ed Meese as he's going out the door, and then, when one works for that Department of Justice and then spends 30 years in academia and sees the Federalist Society do a 100%, almost 100% flip-flop on the appropriate role of the judge in constitutional law, which they've done. 10 years ago, it was a 50. There was a time when Randy Barnett and Steve Smith would argue with each other, and it was a fair fight. No longer. Now the Federalist Society is dominated by people like you, who are thoughtful and smart people who want the Supreme Court to do a whole bunch of things that Ed Meese would never have wanted the Supreme Court to do. When one goes through that, then one kind of realizes that what's really at play here is politics, not meaning. And if there's one thing I can impart to this audience, it's that there is a huge disassociation between the idea that judges should look to the meaning of words with the new originalist idea that the application of the meaning of those words can change over time as facts and circumstances change. That disconnect, which basically makes you a living constitutionalist, the whole idea of liquidation is a living constitutionalist idea. We know exactly, I'll just two more sentences. We know exactly what the original public meaning of the 14th Amendment was when it comes to women's equality. No, it's not debatable. It's not arguable. Chris Green and I have had 10 debates on it. He's lost every one. It's not debatable. People in 1868 did not think women had equal rights. Period. Full stop. Now originalists who claim to be looking for the original public meaning of the 14th Amendment say women have equal rights. That disconnect is about politics, power, hopefully a better appreciation of women's roles, and all of that stuff. I will tell you what it's not about and has never been about, and what constitutional law has never been about, from Marshall to Taney to the Reconstruction Court to the Lochner Court to the Warren Court to the Roberts Court. It's never been about meaning, and it is naive to think it will ever be about meaning. And that is not, well, I have one more sentence. That's not true about Judge VanDyke. That is not true about lower court judges. And the reason it's not true about lower court judges is they have a boss. And my experience with Court of Appeals judges and district court judges is 95% of them, in good faith, take the obligation to follow the Supreme Court's orders, in good faith. To do that, you have to figure out what the Supreme Court is saying. But that's not true for the Supreme Court and constitutional law. They have no boss. I'm waiting for the day, and I once wrote this in a blog post, when the Federalist Society or someone at the Federalist Society writes an article called Legal Realist Originalism. It's coming. In fact, Adrian Vermeule is just about done that. It is coming.
But he's not an originalist. I do have a... beyond formalism and functionalism. It's not up yet, but I don't know. I've been accused of being a functionalist and realist before, so maybe that will do it. But let me ask you this question, Eric, just on that before I finish this arbitrariness. So is it fair to say that the Constitution does not make children born here of illegal immigrants birthright citizens because the framers of the 14th Amendment had no specific intent with respect to children born here to unlawfully present immigrants?
If I understand your question, I always on Twitter today, I don't know if you saw, we had this big debate about stuff like this. There are provisions of the Constitution that are precise. A lot of them. President has to be 35, there has to be 2 senators from every state, and so on and so forth. And I think judges are quite good, except for the 11th Amendment, when it comes to enforcing precise constitutional text. That tells us zero about what the judges should do when the text is imprecise, and 99.8% of constitutional litigation is about imprecise constitutional text. So I don't understand the point of the question.
Well, the point of the question is, you said because the framers didn't have an intent with respect to X, Y, or Z, or they did have an intent with respect to X, Y, or Z in the case of women's equality, we're bound by that intent, even if what they wrote might—
I didn't say that. I didn't say that at all. I didn't say that at all. What I said was, and I'm sorry, I did not say that. What I said was, if the Federalist Society and Originalists today believe that women have equal rights, there are only 2 ways to get them. One is living Constitution. Now, there is a textual argument. Read the 14th Amendment Equal Protection Clause, not Privileges and Immunities, but Equal Protection Clause, and we can maybe get there. But where you can't get there from, you just can't, is what was the meaning of those words in 1868. And that's what you guys purport to do. In your book, in your first book, you talk all about the original public meaning. But we know what the original public meaning of the 14th Amendment was, and it was that women didn't have equal rights.
Okay, I'll tell you what the original meaning of the Privileges or Immunities Clause was. Okay.
Deal with women. Deal with women.
I will right now.
Okay.
Okay. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Okay, what does this mean? If my argument is correct, right, it means the states can regulate and define the content of their rights, but they can't abridge by discriminating in the provision of these rights. Okay. By the way, this does some real work. Okay, this is going back to the challenge you said, well, what discriminates, it's an eye of the beholder. Well, first of all, this does some real work. Okay, if the state tomorrow passed a law that said capitalism is evil, it shall be prohibited to work for wages more than 3 hours in a day, I think that's arbitrary. I think it's irrational, but it's not discriminatory because it treats all citizens the same, right? And so your refuge is in the legislative process. So it does real work. This isn't just substantive due process. This isn't all laws draw distinction. Okay, it does real work other than substantive due process. And on the other hand, monopolies were the quintessential example of an abridgment because you have people who are otherwise qualified, otherwise meet reasonable regulations for health or safety or what have you, and the government just chooses to give an exclusive right to one.
Alon, what is
hold on.
No. You're hypothetical. We're going to lose your hypothetical.
Contempt
We're going to lose your hypothetical. What is the non-arbitrary reason to draw the line at $3 and not $5? What's the non-arbitrary reason? Give me the non-arbitrary reason to say $3 versus $5.
Well, why do you need it? I think it's totally arbitrary. But as long as you tell everybody the same thing, if everyone has a minimum wage of X, or then again, everyone's treated equally, right? It's very different, right? Okay, so on the other hand, we have the monopoly, right? Everything else is going to be harder, right? The more broadly you define the right to earn a living. Okay, well, the state is with reasonable arguments for why bakers should be treated differently than, I don't know, optometrists. Okay, but once you get down to people doing this, seeking to do the same thing, I'm not a baker. I want to fit lenses to your face. So does the next guy, but the next guy could do it because he has an MD in ophthalmology, okay, which has no reasonable relation to this. It's pure rent seeking. It's basically as close to a monopoly as you can get without calling it a monopoly. Okay, what makes that an abridgment, a discrimination? Right? First of all, you have this disparate treatment of people trying to do the same activity, narrowly defined in this case. You can't get much narrower than that. And the restriction is not reasonably related to the purpose of the right or the any sort of plausible government interest. Okay. Again, the broader you go, right to earn a living, well, it's going to be easier for the government to meet that test. But the point is the law, the Privileges or Immunities Clause, or equal protection, but it's privileges or immunities because I'm right about the meaning of this clause, okay, requires us to make that question. It doesn't limit to race. It doesn't exclude the possibility that discriminations against women might be an abridgment, right? Things that don't look like caste on day one might look like caste on year 50. Now, how do I get to women's rights? Well, because we also know that the privileges and immunities of citizens refer to civil rights, not political rights. What's the difference? Civil rights we have in the state of nature, and we come into civil society, and civil society.
Not what it says. It's not what the text says. It's not what the text says.
Well, it's what it means, and that's an empirical question. What are privileges and immunities, right? This was a reference to civil, not political rights.
No, that distinction between civil and political is not what the text says.
Eric, what the text means is an empirical question. And if everyone says, okay, what are privileges and immunities of citizens? Well, they're civil rights, they're not political rights, because political rights, which don't exist in the state of nature, right? The right to vote, hold office, serve on juries, right? The support, maintenance, and administration of government, right? In the words of Bouvier's Law Dictionary, right? These were not rights of citizens. They were rights of a subclass of citizens known as electors. Everyone said it. That's the meaning.
But Ilan, all of that.
Oh, hold on. Let me complete the argument.
You have said in your book and in all articles and to me that if enough things change, the application of the meanings change. You have said that. So this distinction between civil and political rights, maybe that's changed. Maybe we have a world now where women and blacks and minorities and transgender people need more protection. That's not the world of 1868. You can't cabin it that way. Now, the president 35, nothing can change that. The president being 35, there's no state of facts that can make that not 35. But anything, you've just talked about a whole bunch of historical things that are not reflected in the text of the Constitution of the United States. You have. You made it up.
Eric, I do want to hear, that's a very good point too, but I do want to hear, so Ilan, just to be clear, were you going to make the point of how, with your approach, you could get to not having discrimination? I'm still confused to how you can get there. So
okay, so assume this distinction between civil and political rights, right? Which makes sense also as a matter of constitutional interpretation, because if this were wrong, we wouldn't need the 15th Amendment and we wouldn't need the 19th Amendment, right? Because voting would be covered.
So we'll just assume it. I want to know how you assume that, how you get there.
Right. So political rights were the highest form of privileges, right? Reserved to a subclass of citizens, the most elite citizens known as electors, okay? Well, once women get political rights in the 19th Amendment, the highest form of privileges that citizens of the United States can have, this because they now belong to the subclass of electors, all of a sudden, it becomes arbitrary to treat them, in most cases, differently than men with respect to the lower form of civil rights, which, by the way, before you say this is all out of my rear, okay, this is exactly what Justice Sutherland said in Adkins v. Children's Hospital when he invalidated a paternalistic law that put minimum wage laws for women, but not for men. He said after the 19th Amendment, once they get political rights, all of a sudden, right, you cannot tell them that they can or can't do certain things that men can or can't do.
Let me ask you, hold on.
Discriminate in the provision of civil rights.
Let me ask you about that. Hold on, you're going too fast. Hold on. It's your argument. I want to understand it. It's your argument that the 19th Amendment effectively incorporated the Privileges or Immunities Clause or the Equal Protection Clause for women. That's your position.
My argument is the 19th Amendment changes, right, what an abridgment is versus what is a reasonable regulation of the content of a right. Yes, the 19th Amendment changes that.
Really? Because I read the 19th Amendment as having to do with the right to vote. That's how I read that. See, I have this weird, Judge, I got to say, I had this weird view. You read the Constitution for what it says. Like, that's my weird view on this. And
what do you think abridged means? What privileges or immunities of citizens mean?
No, I'm talking about the 19th Amendment. You're putting so much weight on the 19th Amendment. And by the way, in 1948 or 7 or 3, excuse me, the Supreme Court of the United States said that Michigan could stop women from being bartenders. In the 1940s, long after the 19th Amendment, your interpretation of the 19th
They weren't originalist.
Your interpretation of the 19th Amendment, that it basically makes the 14th Amendment applicable to women, makes text irrelevant to all of constitutional litigation. That's all I'm going to which is fine. That's what you want to say.
No, I am loving this discussion, and I'm not keeping it too structured just because this is, I find it fascinating. I hope other people do. Let me ask you this, Ilan. I'm just gonna, because what else would this apply? I mean, so you've talked about race, obviously, and you've got sex. What else? I mean, it seems to me is there any limit to what you're saying, or could you, basically any group that has this highest possible
Transgender, Judge, transgender folks.
Well, anybody that can vote, basically. It seems to me like you're anybody that can vote, which is pretty much anybody over the age of 18 today. You just create these groups, and then you can. So I'm curious.
Yeah. By the way,
your limiting principle.
By the way, if anybody from Cooper and Kirk or some other law firm is listening, the argument you should be making in the Virginia gun case that prohibits 18 and 19-year-olds from owning guns. Because if owning a gun is a civil right, which it is, okay, maybe it's not a constitutional right, right? I'm purely equality, right? If the state allows people 21 years and over to own guns, it's a civil right given to them. 18-year-olds are full citizens, right? Because they have these political rights. All of a sudden it becomes arbitrary to discriminate with respect to civil rights, absent an exceptional justification. Okay, and I think that's why.
So I think we understand. I'm understanding your argument. The question I've got is, basically anybody who's over 18, when the state draws distinctions, it seems like you would be able to say, well, I have the same ability to vote as that other person. So why don't I get
the amendment
distinctions based on age, distinctions based on all of these?
Yes,
Judge, you can be on
the amendment.
time.
The amendment requires that of us. The amendment does not say, no state shall make or enforce any law which abridges the right of citizens on the basis of race. It does not say that.
Well,
so just so I'm clear,
yes,
wait,
it would be,
hold on. Gentlemen, we've only got
be,
about a few more minutes left. And if you don't mind, I want to exercise my prerogative to ask a couple of questions that come to my mind during this thing. And I think you both, and I want to, so I'm going to, and even if you do mind, I guess I'm going to jump in and this is, and by the way, all jokes aside, it really is fascinating. I'm loving this, and I'm sure our audience is too. I'm going to start with Eric. Eric, this is a genuine question that is not really, it's certainly not a legal question, and it's kind of, but so let's say you're right about, there's a lot to be said about your position on your deferential position. One thing that comes to mind, though, I mean, okay, and we have this problem that the more you feed the beast, in the sense of the judges are making these decisions, pretty soon all the decisions are being made by judges, and that's hard to say that's democracy, right? Because every, and it almost feels like we're there. Every important decision in our country gets made by judges. Let's assume for a second that that's a problem. It seems to me like you could have the opposite problem under your system, right or wrong. This is just as a practical. If judges actually did the very rigorous Hamiltonian, they only step in when it's, almost you could call it a constitutional crisis or something. Like somebody's doing something that, like, literally everybody's voted for this guy or a gal that's 30 years old. They're not old enough under the Constitution. Finally, judges have this black and white. But at that point, judges are so deferential that culture's not, we've got maybe the opposite problem now. They're expecting the judges to make all the decisions. But at that point, suddenly they turn around and who's this? Who are these 9 people or these 3 people or this one judge that's saying that we can't do this? They're not used to it. So could the pendulum swing? Could we have, as a practical matter, could we have that problem at the other end to where when it was necessary for them to step in, the institution just had they really were at that point the least dangerous branch?
Right. That's a great question, Your Honor. First of all, de Tocqueville said in the middle 18th century that all important issues get to the federal court. You're saying it today, but he said it, 150, so that it is clearly true that we entrust too many issues to judges, and de Tocqueville said it long before any of us were born. So, I agree with that. So I think the answer to your question, I have 2 answers. I'll try to make it fast. One is I do not advocate and have never advocated to take judges out of the 4th, 5th, 6th, and 8th Amendments. So they will always have the power, because to me, judges are the experts on double jeopardy, self-incrimination, what evidence comes in, confessions, all that stuff. And it's their courtrooms. It's your government. It's your courtroom. You get to decide trial court judges, what evidence comes in, and then your appellate judges get to second guess that. So there's never going to be a situation where federal judges don't have, in my worldview, that authority. That seems obvious to me. That's a very long, a place away from abortion, guns, campaign finance reform, et cetera. I think where I am on your question is I am willing to risk it. I am willing to risk it for several reasons. It's not just judicial review that is so counter-majoritarian in this country. It is our Senate that obviously, Wyoming has the same power as California. That's insane. The Electoral College is reasonably insane. The filibuster is reasonably insane. The seniority system in Congress is reasonably powerful. I'm not sure it's insane, but we have so many counter-majoritarian, influences and restrictions in this country that I guess I'm at the point now where I think if the people, no one's more pro-choice than I am. No, I met my wife giving a talk to Planned Parenthood. I volunteer for Planned Parenthood. If Georgia thinks abortions are wrong and murder, then I don't know why Justice Kagan gets to overturn it. And if the federal government thinks handguns are really bad and dangerous, I don't know why Justice Scalia and Thomas get to overturn that. So I guess I can't really. Someone's okay in the chat. Can I respond to this question in the chat? Because Larry Solomon is the criminal here, and I'll say it to his face. Larry Solomon, in his testimony in the Justice Gorsuch hearing, said, of course, originalism is a good thing because the First Amendment applies to the internet. Well, of course, the First Amendment is in my world, not in Wurman's world, but in my world, the First Amendment applies to the internet. But that doesn't give us any answers as to whether Facebook can be forced to.
In my world, too, by the way. But yes.
Okay, that doesn't answer any of the hard questions that judges have to decide. But going back to your point, I think we should experiment. America is the great, experimenter. I think it's time to experiment with a world where the people get to decide almost everything.
So I think if I could summarize, and I'd like to hear if Ilan, I think what you're saying is, yeah, there may be demons down that road, but boy, we're so far down the other road that you'll take the risk, and that's a valid. Ilan, have you got any thoughts on it? It's not really something you were talking too much about, but.
No, otherwise, I think Devin Watkins' question is more serious than Eric treated it, which is, again, why, so it sounds like you do believe that constitutional meaning can be fixed, and it changes, or its application changes as we have technological or societal changes, right? Which is why the First Amendment applies to the internet, right? So there's no reason in principle that couldn't be the case with the Privileges or Immunities Clause, except that you just think that the Privileges or Immunities Clause is impossibly indeterminate, I think is your view. But I'm here to tell you, it's not. I gave an answer. If it's, there's no invidious discrimination in civil rights under state law, then that can also apply to new and changing circumstances. It's just a matter of you think the 14th Amendment is different than the First Amendment. But in principle, there's nothing wrong with saying the same thing in both cases.
But you started off the beginning of this debate and our debate last year and your book by A, self-identifying as an originalist, and B, saying originalism can save the Constitution from the court. That's your position. And I'm telling you that Mike Dorff and Larry Tribe and Sandy Levinson and Pam Carlin and Nadine Strawson and 55 other progressive liberals would agree with, I'm not talking about the Privileges or Immunities thing, but your method of constitutional interpretation is basically what they would agree with. And I don't understand someone who says that the 19th Amendment can change the original public meaning of the 14th Amendment without ever mentioning the 14th Amendment, without anything ever being said that the 19th Amendment.
The application has changed, Eric. Do I need to chat on the screen?
Well, the thing is, Judge, Judge, I would love to ask, do I get to ask you a question? I would love to ask you a question. Can I ask you a question?
Yes, but I may or may not answer.
Okay. Does anything, so Chris Green and Ilan and I and Will Bode and Steve Sachs, I've debated Steve Sachs, who's now the Antonin Scalia Professor of Law at Harvard, 5 times in the last 5 years on this point. Judge, whether we say that the meaning of the 14th Amendment has changed to a factual situation they did not foresee, or we say the application of the 14th Amendment has changed to a factual situation we did not foresee. Is that ever going to make a difference to any decision you ever make? And I can't imagine that I can't imagine you coming up with an argument that, well, if we're talking about meaning, my answer is yes, but if we're talking about application, my answer is no. That distinction doesn't make sense. There is no, do you think there's an original fixed meaning of the First Amendment as applied to the question, is obscenity speech? Or can we make Facebook not censor people they want to censor?
Well, I think, so I'm not sure that for your critique to have some persuasiveness, you even have to go that far, because even if the original meaning of if there's, I recognize you dispute this, but there's an original meaning that you can ascertain, and that original meaning, I'm basically going to take your question. I'm going to flip it towards Ilan, because it's something I wanted to ask Ilan, which is, given that Ilan has said multiple times that there's a range, sometimes there's obvious answers. Is the person, what's the age limit, right? Let's use that one because that's easy, right, for a president. But you've said, Ilan, and I think you're right, that there's a range of plausible answers. And it seems to me, having in my short time on the bench, those are the hard cases we get, are the ones that fall within that. And I'm not exactly clear. I mean, it's kind of the question I think that Eric was kind of positing at me. So when you get that question, and you get the question about a constitutional issue, and so let's just use his example, because of the fact that you're trying to apply a constitutional provision to a technology that did not even exist. The internet we've talked about, we all know the cases, right? Let's say it comes up, you come up with a range of plausible answers. The litigants give you both. They give you both arguments for why it should or should not apply or shouldn't. What do you do with that, with the range of plausible answers? Because it seems like many of the hard cases fall in there. And I think you talked about this liquidation concept, I think, but it seems like we are trying, the attractiveness of originalism and textualism is to avoid feeling like judges are just making it up and imposing their own personal views. But when you're talking about, well, apply it as a rule once it becomes liquidated. And, when we talk about a range of plausible answers, it starts to feel a little bit like that's hard. Like, what do we do? What do you do in those circumstances? What is the theory of interpretation for those circumstances?
So the theory interpretation doesn't change. It's a question of what do you do when you're confident, depending on how confident you are that the answer is.
Let me one more. I'm sorry, just because Judge Segall's, we all might disagree about when we fall in those categories, but his answer is, he thinks it happens a lot. Let's say you don't think it happens as much, but what's really interesting to me is what his answer is. Let's say we all agreed we were in one of those indeterminate circumstances, and his answer is, as judges, we should sit back and let it roll. But what is your answer as judges that we should do in those circumstances?
So there are four possibilities that I'm going to lay out, and I'm the fourth one. One possibility is to say, look, there's a range of meanings. By the way, what happens when you disagree over the range and the scope of the range, right? At some point, you have to make that decision. But let's say we're within the range. What do we do, right? Well, the question is how confident you are that you have the best answer within that range, admitting there to be ambiguity. So some people will say, like Judge Segall, he would say, look, I think unless I'm 80% sure, I can say with 98 clarity, right, that the answer is otherwise, I'm going to go with what the legislature has done. That's one possibility. Randy Barnett is going to say, the opposite, right? Unless I'm 80% confident that the legislature has this power, I'm going to do it in favor of liberty. A Mike Rappaport and John McGinnis will say,
just to be clear, Ilan, are you going down the four, or are you just?
Yes.
Okay, yes. So Randy's number two.
One is basically presumption of constitutionality, a very strong form of which I think Professor Segall is mentioning.
Yep.
There, right? The other is the presumption of liberty, as channeled by Randy Barnett and maybe Richard Epstein. It's Harry. Okay. And then the third is the McGinnis-Rappaport view, which is, look, the judicial duties as judges have to decide, which according to them, if you believe that the answer is 51% in one direction, 49% in the other, you go 51%. Okay. For me, the answer is, look, the judicial duty says in this case or controversy, as applicable to these two parties before me, this is where departmentalism comes in because it lowers the stakes a bit. I have to decide what the answer is as a judge, but I would not go 51-49 because I could be wrong. And I want to give deference, some amount of deference to other people who might disagree and just have humility. I'm in front of the Senate Judiciary Committee and it's my confirmation hearing, okay? If I were 60,
I'll vote for you, by the way, I will vote for you.
That the answer is X, okay? Even though it's plausible that the answer is Y, I will go with answer X, even if that means overturning a law of the legislature or Congress. My ruling will be applicable to the cases before me. And over time, other judges might disagree.
So I hear what you're saying, Ilan. So
what a great judge I would be.
What you're saying is, I'm going to do, it sounds to me you're going to go with option 3, but don't worry about it because the impact of any given decision that I make is not going to be a very big deal because, it'll only impact the parties in front of me.
If I might.
Correct, but I wouldn't do 51-49. Just
hold on. I really want to say
humility
something.
Thing.
I've been
I would do 65-35.
Judge, I want to say a lot.
Okay, I'm sorry, Eric, just to be clear. That's so I understand you're 65-35. So you have a small version of what Eric's saying. If it has to get up to 65 before, is that what am I understanding, Chris?
Yes, only because I could be wrong and I want to acknowledge that. And I want to acknowledge.
Yeah, okay, I hear Buffalo. So Eric, what were you going to say?
No, I want to say, and by the way, since 2017 or so, I really like finding common ground. I think our country needs that. These students need that. So there's a lot I agree with in what Ilan just said about his departmentalism in this sense. Other countries have done that, right? So, I mean, in a lot of other countries, the judicial decisions about the constitutionality of certain things are what we might call advisory opinions. They're a little stronger than that, but they're somewhere between advisory opinions and binding. And they're only binding really based on the strength of the logic and reasoning of the decision. Of course, Canada famously has this, not used ever, but the threat is there. If the legislature disagrees by 2/3, it can overturn a Supreme Court decision. I think going down that road is very helpful and very fruitful. And maybe Ilan and I write a book about that someday, because I think we could find a lot of common ground there. I really do. So I'm interested in what Justice Roberts.
So we got 3 minutes left. Here's what I'm going to do. I apologize to a fascinating discussion. I'm going to give Ilan, I'm going to give you 1 minute, and I'm going to cut you off. And then Eric, I'm going to give you 1 minute. Then I'm going to take 30 seconds to wrap it up and then turn it over to Samuel.
Sure. I didn't prepare sort of a closing round. So what I would say is a big premise, okay, of a lot of this non-originalist critique is that the Constitution is so indeterminate, so vague, it's glittered with majestic generalities, okay? Combine two things, sometimes you hear glittering generalities, so glittered with majestic generalities. That premise is just wrong, okay? In my view, if you do the work, and yes, people are gonna disagree, okay, because of the fallibility of human reason and so on, but I'm right about this, okay? So if you just do the work, it turns out the necessary and proper clause has a relatively determinate meaning, right? Implied powers, lesser powers, not great and substantive powers. It turns out the Ninth Amendment has a pretty determinate meaning in terms of a rule of construction. It turns out that the privileges or immunities clause has a pretty determinate meaning, or at least a limited range of meanings, okay? So don't believe the nonsense about these majestic generalities. The Constitution does a lot more work than you learned.
All righty.
What I find interesting about how Ilan started that was this non-originalist critique. You know who I side with? Alexander Hamilton. I side with Brutus. And most importantly, there's a case called the Prisoners' Cases, or Prisoners' Case, I forget, from before the Constitution was ratified, where a lot of the founding fathers were involved in the case as advocates or judges. And that's the first real discussion of judicial review that we have, or one of the first major ones. The Dean of Georgetown has written a lot about this, former Dean of Georgetown. And in that discussion, in the veil of ignorance, they all agreed. If we're going to strike down laws, we are only going to do that when we are really sure, and we don't want to do that, and we're going to do it humbly, modestly, and rarely. So the fact that someone is calling me an anti-originalist, when I'm the only person who was relying on sources from 1780 to 1797, but how to interpret the Constitution, is the height of irony, especially at an organization that Ed Meese founded.
Well, thank you, Eric. I genuinely, all the joking and hyperbole about our fight, this has been really, I really enjoy it. I love it. I hope that you both will start preparing for next year's rematch. And we've got to do this again, same time, same place. And with that, I'm going to turn it over to Samuel to wrap things up.
Yeah, thank you everyone for joining us this evening for an exciting debate. This was fascinating. I personally could have done this all night. It's very encouraging and refreshing to see a robust and rousing debate on important issues, and all done with a smile. So thank you to you both, Professors Eric Segall and Elon Wurman, and to our referee, Judge VanDyke, and to you all in the chat for your lively participation. I'm sorry we didn't get to questions, but I think that we covered some good ground there. I would invite you all to join us on November 17th. We have another Feddie night fight scheduled with the St. Louis University School of Law. It's titled New York State Rifle and Pistol Association v. Bruin. What rights does the Second Amendment guarantee outside the home? And your fighters there will be Stephen Halbrook and Patrick Charles. Again, 8 a.m. and you can register on the Federalist Society website. So thanks again, everyone, for coming out, and good night.
Now that will be